Yes, sir.
Camera yaak bartalla. Oh, it says can't find camera. Okay, I'll just try to do something and come back. Huh? Okay.
Yes, sir. Okay.
Court officer, am I audible?
You are audible, sir.
Thank you, madam.
Court officer audible ಇದೀನಾ sir?
ಇದಿರಿ. I will on the switch on the video. Wait.
Madam audible ಇದೀನಾ?
Audible ಇದೀರಾ?
Thank you, madam.
ಸುಮ್ಮನೆ ಅಟೆಂಡ್ ಮಾಡ್ತಾರೆ. 2 ಸೆಕೆಂಡ್ ಇದೆ. ಆಯ್ತು 2.
Stays there. Which year is that? Visit on Monday.
Monday.
Tuesday.
Tuesday.
Yes, yes. Tuesday.
Ah.
This is matter on Wednesday. Yes.
Wednesday.
Hmm?
Next Wednesday. ಇದು ನಾಳೆಗೆ ಆಗ್ತದೆ.
Which year is the petition? Visit on Wednesday.
Wednesday.
Yes.
Page wise assignment. First one. Page 2.
Let's serial number 7, my lord.
4.
Serial number 7.
Page 3. Serial number 6 to 11.
My lord, serial number 8, my lord.
7, somebody.
7, my lord. Maybe accommodate after 2 weeks, my lord.
Just have to await service of notice.
Much.
Serial number 8.
Just after service of notice.
Serial number 8, my lord, there is only continuation of delay of 125 days, my lord. I have some inconvenience can be taken next week, my lord.
Somebody has moved the memo.
Yes, Shetty.
I have moved the memo. Reason for moving the memo is that the revision petition is pending before this court for still from 2022. No maintenance is paid. There is a daughter, my lord, and she is suffering from some medical ailments. Maintenance was also granted, and she was the husband was also directed to pay medical expenses. Nothing is paid.
I'll just make a submission. There is no interim order operating. Nothing stopped him from enforcing the order. Let him not come here and say all these things.
Maybe true.
What is stopping him from enforcing the order before the court below?
This type of submission.
Not this type of submission,
He
my
is
lord.
from Bangalore. He is evading the.
No, I am not from Bangalore, my lord. I am from Pune. I am from Navi Mumbai,
That
to
is
be
the
frank.
difficulty.
Your lordship will see the cost title also.
Mangalore, the warrant will never go.
And this is for continuation of delay. And your lordship may take it next week is all I'm saying. Date may be fixed is all I'm saying. Some inconvenience is there, my lord.
This is smart after 2
May I
days.
make one request? Let them serve a copy. We have not received any copies.
But let-
I'll definitely do that.
Let the copy of the petition on the council appearing for the respondent. Yes, next.
Any date is fixed, my lord?
She'll give the date after.
Please, my lord.
21/7. Serial number, page number 4, serial number 12 to 17. Serial number 17, my lord. Appearing for the petitioner. Kindly 1 week time may be granted, my lord.
Why for the fresh matters also time,
Yes, my lord, some means personal inconvenience.
a week's time?
Date may be. Serial number 10,
Yes.
10/7. Much. Page number 5, serial number 18 to 24.
22, my lords. 22, I appear for the petitioner. I pray for a week time, my lords. Council is.
This is also fresh matter.
My
Why are
lords,
they listed then?
let's see, council is not in record.
What is there for an RPFC for asking for time when it coming for admission?
My lords,
Either it's a case for interim order or not. We'll order notice. For that, why adjournment? You are also sufficient. Be here.
my lords, the file is not with me, my lords. The council, the on-record council is
The
not.
matters just like this.
But
Fresh matters, what is the
I
adjournment?
request a week, my lords. That's it.
This matter after 4 weeks.
So, minutes, serial number 23 minutes, only for filing joint memo minutes. The matter has been settled minutes. I may request for Monday minutes. For want of signatures, it could not be paid. Settled only for filing joint memo. Request.
Why all the time, at every point of time,
No, but
lapses on your part?
yesterday evening they have shared that finalized.
He was there, very much there on that day. He came to the chamber.
He was there,
before
madam.
yesterday.
We shared the memo. They have rectified it and they have written it yesterday evening. Madam. Only the difficult.
And then what you will do now? Today you will send it. Will come up after.
No,
how
madam.
much time?
He will send it by courier. He said it, madam. Requesting for Monday, madam. We'll file it in the registry.
Have you informed the other side?
I have informed the other side. Today I am not able to.
Matter
Please.
on Monday.
7. List number 2, serial number 1. Page 1. List 1, serial number 1 for dismissal. MR Hiray method.
It is submitted that on 17/6/2025, it is submitted before the court that the petition is no more and sought time to file a memo to that effect. This was on 17/6/2025. Thereafter, this matter has come up on 27/6/2025. On that day, there was no representation on behalf of both the parties. And some matter was actually registered for dismissal today. Today also there is no representation. Considering the submission that the petition is no more, that the RPFC is dismissed as a vacant.
Serial number 2 for
Yes.
withdrawal.
For withdrawal.
A memo is filed stating that the dispute is amicably settled between the parties. And so as such, the petition is not interested to pursue this petition. Accordingly, dismissed as withdrawn.
Serial number 3, I appear for the petition, my lords.
Yes.
On last time it was came as unclaimed, my lords.
Not raised.
Office was directed to place it on record, my lord.
Unserved covers, what is that? Refiled but could not be traced. Unclaimed returned to sender. The notice to respondent returned as unclaimed as per the postal shara dated so and so. The notice to respondent is a deemed service of notice in the name of the party. This is matter on Thursday.
Grateful, my lords.
Serial number 4.
And for petitioner, my lord, I filed this for withdrawal, my lord. So with liberty to file before the appropriate forum.
The appropriate.
It has to be appealed before the sessions court, my lord. This was a NOC wakalat given to us. The previous council has filed this writ petition before this honorable court.
What was the order impugned?
To enhance the maintenance, my lord.
To enhance the maintenance, why should it go to the district court?
No, it was ordered by the honorable magistrate court, my lord, in criminal miscellaneous 162 of 22.
Lords, I may be permitted to make a submission, Your Lords. There's a subsequent writ petition, Your Lords. Order was passed in the February month in the year 2024, Your Lords. Thereafter, we have sought the writ petition before the Honorable Lordship itself, wherein the Honorable Lordship has remanded the matter, directing the magistrate to take the matter afresh, wherein they have contested the matter 3 times so far. And again, after that order has been modified, they're again coming before this court, filing again writ petition, challenging the order, Your Lords. This is what they have been doing.
As I made my humble submission, my lord, this was NOC wakalat given to us.
No,
The
no,
previous council has.
One minute.
Please.
Come to the order. Where is the order? This order is dated 21/9/2022.
Your Lordship, may be permitted to file a synopsis.
Hmm.
We had initiated the proceedings in 69/22, Your Lords. Thereafter, after lapse of 2 years, that is on 22/2024, the order on IA number was allowed, Your Lords, wherein they have granted us the interim order of 20,000.
Your for the wife.
Yes, Your Lords.
Wife or husband?
Wife, Your Lords. Thereafter, on 15/3/24, we have sought a writ petition before this honorable court, wherein your honorable lordship itself has passed the order in spite of serving the notice to the husband. He has failed to appear before this court. Thereafter, your lordship.
Come to this 27/5/2024 order.
Yeah.
It is at page 61.
Yes, Your Lords. As the husband has not appeared, this court has directed to take the matter afresh, Your Lords.
Now, the order which is impugned in your writ petition
Please,
is set aside in another writ petition. Is set aside and remanded.
Please,
Where is the question of giving liberty to you to file a writ petition?
not writ petition, my lord. Before the session.
Not writ petition, whatever it is, because
Please.
that order is set aside by the High Court. That order is set aside, matter is remanded. You are contesting that matter. You have to contest. There is no question of remand. I'll record this and permit you to withdraw this. MMO is filed, seeking to withdraw the writ petition, stating that they may be permitted to withdraw and seeking permission to withdraw as against the order passed by the magistrate. They have to go before the district court. And instead of that, they have come before this court. The learned counsel appearing for the respondent submits that against the very same impugned order, the wife had filed WP number 14474 of 2024, and this court has set aside the matter and remanded the matter to the court below. And the husband is also contesting the said matter. When once the order that is passed by the court is set aside, there is no question of granting liberty. And in the light of the order in WP number 14474 of 2024, nothing remains to be adjudicated in this petition. Accordingly dismissed.
Number
Grateful, Your Lords.
5,
Congratulations.
Jagadish.
Appearing for the petitioner, my lord.
Yes.
My lord, we comply the office solution. Kindly 1 week time may be granted, my lord.
Default order.
Cell number 6.
What is this?
Petition.
Why the memo is moved
Because
and
what had happened, Your Lordship, the writ petition filed against the order passed by the MC court passed the order for the issue notice to the impleading applicants. Because originally what had happened, Your Lordship, it is filed before the Mysore court filed by the husband for the divorce, and we appeared and we filed an application for maintenance before that court, Your Lordship. Subsequently filed before this court for
came on the point without complying with the office objections. Why the memo is moved?
Because they have sought for the original objection, Your Lordship, because I filed the writ petition for the impleading application for the order for the impleading application, not for the original application they sought for. original application for the divorce petition we have filed. It is filed for the writ petition filed for the application filed by the respondent petitioner before the MC court, avoiding the maintenance order, because they never passed the order of maintenance, because from the Mysore court to Bangalore court, 2.5 years we are suppressed.
You are appearing for whom? Wife?
For wife,
husband?
Your Lordship.
You are appearing for wife.
Yes, Your Lordship.
Then why the wife is not having the petition and objections?
Objection filed, we are not going to produce before this court, because it is objection raised by the office. For we have sought for against the application filed by the petition before the.
Generally, that also they seek, MC.
For this matter,
petition,
I will.
Objections, IA, objections, and the affidavit.
Because
That
he sought for main objection, Your Lordship. That's why I am
So
saying.
what is wrong in it? That is
I
in
will
the
produce the same. I am not.
Do it. Office objection shall be complied with.
Week maybe, time may be granted.
Is this matter after the week?
Yes, sir.
Cell number 7 and 8.
If the office objections are complied with.
Yes,
within
sir.
a week,
I will complete
this
the
is a
office
matter. This is a matter immediately. Yes.
9. Nirmala Krishna for petitioner.
I am for the husband.
Notice.
I am challenging the impugned order passed by the.
Notice. Notice the respondent.
Cell number.
My lordship, the court below has issued a warrant.
It will
against
issue warrants if your order is not complied with, and casually you come to the court whenever you remember.
She is working, my lordship. It is an admitted factor in her evidence that she is working before prior marriage and now.
How much is the maintenance granted?
10,000 till her lifetime, and he is.
What is your income?
My income is 15,000 to 1517. I am the daily wager, and I am also attending the court proceedings.
Come to the order.
scholarship. I have adduced my evidence, my lordship, in that she admits that she is working, and she also admits that he is not having sufficient.
Please come to paragraph number 12 and start reading it. You filed your statement of assets and liabilities.
Yes, my lord. Including bank statements. Annexure G, my lord.
Where is it that she is working? Where it has
In her
come?
evidence, she admits that. Page number 59, 49, and cross-examination of PW.
What she says in the cross-examination?
In that she says that when she married, she did know that he is not working and he has not got any immovable or movable assets. And she is working at the time prior and after the marriage. And she is to
What
get.
was she doing as on the date of the petition? What did she say about that? Not about working prior to marriage or in the course of marriage. Once she is out of the matrimonial home, was she working? Is it her case?
Still working, my lordship.
Where is it? Read that
It
sentence.
is page number 54, my lordship. 53. Para 6 in para 9. Nanu
Paragraph number 6.
6, my lordship. And that is the at the time of during the marriage. ದಿ ಬೆಂಗಳೂರಿನಲ್ಲಿ ಇದ್ದಾಗ ನಾನು ಬೆಂಗಳೂರಿನಲ್ಲಿ ಇದ್ದಾಗ ಎದುರುದಾರರು ಒಂದು ಕಂಪನಿಯಲ್ಲಿ ನನಗೆ ಕೆಲಸ ಕೊಡಿಸಿದ್ದರು ಎಂದರೆ ನಿಜ. ಎದುರುದಾರ ದಿ ಪೆಟಿಷನರ್ ಅಂಡ್ ನಾನು ಟಚ್ ಪಾಯಿಂಟ್ ಟೆಲಿ ಸರ್ವಿಸ್ ಎನ್ನುವ ಸಂಸ್ಥೆಯಲ್ಲಿ ಮಂಜುನಾಥ್ ಎನ್ನುವವರ ಕೈ ಕೆಳಗೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೆ ಎಂದರೆ ಸರಿ. ನಾನು ಹೊರಗುತ್ತಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರಿಂದ ಸಂಬಳವನ್ನು ನೇರವಾಗಿ ನನ್ನ ಕೈಗೆ ಕೊಡುತ್ತಿದ್ದರು ಎಂದರೆ ಸರಿ. ನಾನು 2 ವರ್ಷಗಳ ಕಾಲ ಸದರಿ ಸಂಸ್ಥೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡಿದ್ದೇನೆ. ನಾನು ಕೆಲಸಕ್ಕೆ ಸೇರುವಾಗ ತಿಂಗಳಿಗೆ 15,000 ಸಂಬಳ ಕೊಡುತ್ತಿದ್ದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನಗೆ ಬರುತ್ತಿದ್ದ ಸಂಬಳದಲ್ಲಿ ನನ್ನ ಜೀವನ ನಿರ್ವಹಣೆ ಮಾಡುತ್ತಿದ್ದೆ ಎಂದರೆ ಸರಿ. ನಾನು ಎದುರುದಾರರ ಮನೆಯಿಂದ ಬರುವ ಸಂದರ್ಭದಲ್ಲಿ ಎದುರುದಾರರು ಮನೆಯಲ್ಲಿ ಇರಲಿಲ್ಲ. When she left home voluntarily, he was not there at the time of.
That is not relevant. What I want to know is what did she say about
in the 54.
Salary directly to her husband, and moreover, she denied that she is not resigning in the house of that person who secured the job for her.
In page number 54, she says that ನಾನು ಈಗ ತಂದೆಯ ಸ್ವಂತ ಮನೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ.
Now at present she is residing in the.
Please
ನಾನು ನನ್ನ ತಂದೆಯ
only that line.
That is the line I say. ನಾನು ನನ್ನ ತಂದೆಯ ಆದಾಯದಿಂದ ಮತ್ತು ನನ್ನ ಆದಾಯದಿಂದ ಜೀವನ ನಡೆಸುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ.
Both the income of his father and her father herself, they are leading their life.
Do that. Then counsel for the petitioner submits that the petitioner is earning an amount of rupees 15,000. The court had granted an amount of rupees 10,000 as maintenance. And in fact, in a cross-examination, the wife has admitted that she is working, and it's difficult for the husband to pay the amount. Then said they stay of all further proceedings on the condition 50%. Arrears at 50%. And notice to the respondent. Yes.
Till number 10.
On IA number 1 also. Yes.
Preparing for petitioner, my lordship. My lordship, IA number 2. Wait for my lordship. The petitioner paying an interim maintenance of rupees 6,000, my lordship, which was filed in the DVA.
How much is granted by the court?
My lordship, the interim maintenance was granted for rupees 6,000, my lordship, which is.
How much?
6,000, my lordship, which is complied by the petitioner, my lordship. And like meanwhile, she filed a 125 proceedings, my lordship, in which the court has filed a maintenance of rupees 12,000, my lordship, which is.
No. In this case, how much it is ordered?
To 12,000, my lordship. 8,000.
8,000 plus 4,000, 12,000.
Yes, my lordship. Already he is paying maintenance in a DV Act, my lordship.
How much?
6,000, my lordship.
What is your income?
Income, like I am dependent on the parents, my lordship.
What is how is it recorded by the court? Come to the order.
Page number 16, my lordship. Like 12th line, my lordship. The petition number 1 has studied.
The petitioner has stated that the respondent is having 14 acres of arecanut plantation.
My lordship, it's not my own property, my lordship. It's our father's property, my lordship, where I am.
1,50,000 per month.
My lordship, they have not produced any documents, my lordship. Yes.
He also owns 4 houses at Bypass Road, Shimoga.
Nothing is in my name, my lordship. I am just a matriculate, my lordship. I have just studied SLC, my lordship.
So having you studied SLC, then it will not stop you from enjoying the the properties.
Yes, my lord. The first petition was filed in the court of Shimoga, my lordship, like overlapping jurisdiction, my lordship. The first petition was filed in the court of Shimoga, my lordship, and this petition is filed in Chikmagalur, my lordship.
Did you raise that objection?
Yes, my lord.
It is submitted that in the domestic violence case, the husband is paying an amount of 6,000. Again, the court had granted 12,000 in this case. The petitioner is not
The
in a position
FLW was issued and he was arrested on 26
is not
6
in a
25.
position to pay the same. Same in this also, another 6,000, 50% notice. Yes.
Seal number 11,
Hearing for the petitioner.
Krishna Gowda.
436 days will order notice.
My lords, if I may be permitted to make a submission, kindly look at Annexure A, my lords. She itself admits that the petitioner
That's not, will not at all go into the merits of it.
My
You're
lords,
coming
there's
to
an
the court
NBW
after.
which has been issued, my lords. I may
Why
just
did
be
you
permitted, my lords.
First of all, tell the court what is the reason for the delay
Yes,
of.
yes, my lords. The
Let-
delay,
Give the affidavit stated in support of the IA. Whenever you remember and whenever you want to come to the court cannot
Yes, ma'am.
permit you to,
but, there was multiple criminal proceedings.
whatever
at
it
that
is,
time.
whatever it is, let me.
Lords,
under-
which was
if the-
resulted in
If the reasons in support of the IA are convincing, then only I'll interfere.
Yes, ma'am.
Otherwise not. Which page number is your IA?
Lords, after the state, 48, 49, my lords. IA number 2.
IA for condonation of delay. Yes, please.
My lords, at para 4 of my affidavit, my lords, there is this
Order was passed on 4/12/2023.
4/3/2023, my lords. In the meantime, my lords, I'll just give you a background of the history.
Let's
And my
read
lords,
your
it's pertaining to this. My lord,
Let's read your affidavit.
yes, my lords, with
Yes,
4
please read your affidavit.
to further understand.
No, not necessary. I can understand. from
Okay.
affidavit.
At para 4, my lords, I clearly state that there was an 376 charge filed against me. An FIR was filed against me by one lady called Pankaja, saying that basically, my lords, there was a 138 proceedings against me initiated by Miss Pankaja in the civil court, my lords. Pursuant to that, there was an NBW issued in the 138 case, and I was not aware which case has been filed against me. And my lords, and why I'm telling you, I need you to have a look at the Annexure C, my lords, that mutually agreed.
So, do you call it an affidavit under Section 5 of the Limitation Act? Where did you say, when is the order passed and why you have not come before the court? One line in this IA? Why should the court entertain why not a dismiss this?
No, the IA is only, my lords, I'm pertaining to that. It's the para number 4 is quite clear as to why I couldn't attend. My lords, he didn't even know that there was such proceedings initiated against him because he was held up in certain other false cases which was filed
To
against.
the order, let us see what did the court say about with your notice and all. Because without notice, court will not pass orders.
Yes, my lords.
What happened to that?
My lords, the notice first they've issued through RPAD, my lords. But it has come as
Let's see
answer.
from the paragraph, from the order,
Yes, ma'am.
what
One.
it says.
My lords, at page number 5 of the judgment, that is page 17 of my petition.
Yes.
Para 3, my lords. After registration of the petition, notice was issued to the respondent through RPAD, which was unserved. Later, notice was issued through the concerned police, which was duly served. My lords, that's exactly why I wanted you to. I've added that point in my affidavit, the para 4. At that point of time, he hasn't even realized which summons has been served through him.
You can, if you look at the summons, you know what is the court, what is the
Lords,
case
when a
number.
man has been harassed constantly
But
over
that's
various
not the way
criminal
we look at
proceedings.
That's not the
My
way we
lords,
look at things.
lords, there's an
I'm
NPW
not
issue.
inclined to interfere. Notice, let him go inside. Notice.
Seal number 12,
Much okay.
Petitioner in this case, my lords. For petitioners in this case, my lord.
Yes.
I was suffering from ill health. That is why I could not approach the advocate. That is why delay.
2406 days notice.
Suffered from jaundice, madam.
Next 30.
Cell number 13, Sophia for petitioner.
Yes. What is the modification?
My lord, in this case, my lord, the petition for custody of child was filed
Let's see,
by.
11/12/2023. Where is the order, or what is the order date?
Yes. My lord, may kindly peruse the order sheet of
11/12/2023.
case, my lord.
11?
11/12/2023, my lord.
No, go before the very same judge. The order, this petition
Lord,
again
my
is
only-
filed.
My lord, may
Your
kindly
lordship-
see, my lord, the child is suffering from ADHD, my lord.
Whatever it is.
Only one
Your
submission, my
lordship,
lord.
we have
Only-
come forward with some proposals and why we do not want.
The IA number 1024 is filed seeking modification of the order dated 11/12/2023. List this matter before the very same judge
My lord, if
who has
may be
passed the
given, my
order.
lord. If a date can be given, my lord.
How can I give a date for somebody else?
My lord, because only thing that I'm asking
Your
is let
lordship,
me.
we have come
I can't,
forward
I
with
can't.
some
Let the visiting
proposals.
Next,
at home, my lord.
next. Go to the registry and ask for the date. They have to talk to the judge who is not here. Huh? Not listen.
Cell number 14, Azhar Mir.
I appear for the petitioner, my lady. On the last occasion, my lady, I had served my acknowledgement has on the trial court. My lady had instructed me to file a memo detailing on how I had served the respondent, my lord. I filed it on the previous date, 36/25.
Dated.
36/20/25.
It is submitted, a memo is filed stating that as per the order passed by this court, the petitioner has served the hand summons on the advocate appearing for the respondent before the trial court. That is Mr. S.A.H. Razvi.
My lady, if you may just submit, I served a copy of the petition to the trial court respondent, the trial court advocate, and hand summons was attempted to issue to the respondent, my lord.
Why not to the advocate hand summons? That should have been the correct procedure. That's the way, then otherwise they'll come up with something else. The petitioner shall serve the counsel, the petitioner shall serve the hand summons on the counsel appearing for the respondent and shall file a memo to that effect. When can you file the memo?
My lords, 18th, my lords, by 18th I'll have it.
List this matter on 18th.
Cell number 15.
Appearing for the petitioner in this case, your lordship.
Yes.
In this petitioner, the wife has filed an application seeking interim maintenance of rupees 30,000 and 50,000 for litigation expenses. However, an amount of rupees 4,000 per month and 2,000 towards litigation expenses has been ordered.
Enhancement. Notice.
Cell number 16.
Yes, your lordship. Your lordship, one more thing. So far, the respondent has not paid any maintenance from the date of the order. So I'm seeking stay of the further proceedings of the MC petition, your lordship.
But you have a remedy to file an IA before the court itself. Yes.
Cell number 16.
I'm for the petition on this matter.
Yes.
And representing the plaintiff lady at the court below, my lord. It's a declaratory suit challenging the very registration of marriage because I was cheated into this. There was an engagement which was conducted.
What is the impugned order? Where is the impugned order?
I'm asking for directions that this the matter be completed in next 3 months, my lord.
Which court it is?
5th Additional Family Court, Bangalore.
Which year is this petition?
2023, my lord.
There can't be such direction.
My lordship?
There cannot be such direction. There is a specific direction that the matters of till 2019 shall be given importance. No urgency for this.
My lordship, it has taken 1 year for framing of issues, my lord. And the last time it was.
No, please understand there are matters of 2016 are also pending in the family courts. How can there be a direction for a 2023 matter?
Lordship,
It can't be.
she's a young girl, my lord. She has a future. She's a young girl. She has a future. At least,
That's a problem. But there can't be, because court cannot direct like that. The
at least
representative
expeditiously, my lord.
is filed because the High Court on administrative side has already issued instructions that they should deal with the matters till 2019, not the other matters now.
The dates which we are getting is 10/6 was the last date. The next date is 23 of August, 2.5 months.
No, from now onwards, they will not take up any matters except urgent IAs, other than 2019 matters. Till 2019 only they'll take up. The writ petition is filed seeking the following relief. The matter is pending before the fifth additional family judge, Bangalore, family court, Bangalore. Then counsel submits that there can be a direction to the respondent to the court to dispose of the matter.
Because in this case, there was no marriage at all, my lord.
Whatever it is, Mr. Counsel, we cannot, there is no exception. Everybody has to come in the same way. What is the time frame you sought?
I sought for 3 months, my lord, because it's already come to the matter of evidence.
To give a direction to the court to dispose of the matter within 3 months. The three-judge bench of the Honorable Supreme Court has passed, has held that unless and until compelling circumstances, the High Court cannot direct the courts to dispose of the matters out of turn. This matter is pending on the file of the 5th Additional Family Court, where there are about 2,000 matters are pending, right from 2016 till now to 2025. And this court cannot direct the court to dispose of this matter out of turn, and there are no compelling circumstances that warrants an order from this court. Hence, this court finds no reasons to direct the court. Accordingly dismissed.
17 adjourned. Cell number 18. S.V. Prakash for petitioner.
Yeah, petitioner. But this is yesterday's matter.
Yes.
Now, there are 3 petitions not filed by the parties.
You want a disposal. Which court is this? Oh, that is from principal court.
Yes, yes, my lord, yes, my lord, yes.
Yes. So what will happen now if it is transferred to the first edition?
My lord, I understand. I cannot choose the court. So my request was, my lord, the respondent filed criminal petition, miscellaneous petition under section 125. My lord, that is still pending before the principal judge. And that is, my lord, the fag end of the trial. My lord, there is an application filed under section 340. And my lord, the husband files, my lord, in the year 2000, this has happened in 20, criminal
I
miscellaneous.
understand. Yesterday you have submitted the facts. I understand. Now, there are more number of cases in the principal court, less number of cases in the first additional court. So, one matter is pending here, 2 matters are pending here. Court thought it would be convenient to transfer the matters, and for you also it's convenient, less number of matters are there. It will be convenient for the other court to dispose of your matter. So, what is the difficulty?
No, I understand that, but my request was, Suppose the principal judge himself on his own, my lord, because of this reason he transfers, there's something different. But here, my lord, what happened is, my lord, I requested additional judge to transfer, my lord, the petition which is pending, my lord.
That
For,
he cannot do.
no, he can't do, but I applied it, my lord, he rightly rejected. I don't find any, my lord, fault on him, rightly, because, my lord, that power is vested in the principal judge.
Yes.
My lord, then, my lord, after the additional judge refused to do this, my lord, respondent, my lord, files a memo before the principal judge, and she requires to transfer, my lord, this my petition for restitution of conjugal rights to the court of, my lord, additional judge. Now, what I requested is, instead that, my lord, since, my lord, the learned principal judge has recorded evidence in my petition also, that is, my lord, for restitution of conjugal. It is at the fag end of the trial. My lord, he has recorded the evidence.
No, so many judges are transferred. In May, some other judge might have taken charge at principal court. So how does it matter? Whether he hears it or first.
No, that's all right, my lord. In every case, it is not possible for the judge to, my lord, record the evidence to decide. I understand, but here, my lord, both, my lord, criminal miscellaneous petition and, my lord, my petition for restitution of conjugal rights, my lord, they are now at the fag end. My lord, the cross examination is over. Then, my lord, next stage is argument.
If it is transferred, it would start from there only.
No, I know that, my lord. I know that. No, my lord, our request was that since they are already two petitions at the fag end of, my lord, the trial, my lord, at this stage, my lord, the learned principal judge could not have transferred it to, my lord, the additional judge. Now, that is the only submission.
Please come. Present writ petition is filed and the orders on memo filed on behalf of the respondent. The memo is filed on 22/2/2025 by the respondent to made over all the cases to the first additional family judge, as the respondent filed MC number 106 of 2024 against the petitioner seeking divorce, and the said case is pending on the file of the court, and to decide both the cases together. To that, the objections are filed, stating that memo is not maintainable, and the respondent is aware of the pending criminal misdemeanors number 79 of 2020 on the file of the principal court, and could have filed a memo to made over the said MC number to this court. And in fact, the petitioner herein has already filed a memo before the first additional court to transfer the said MC to the principal family court, and the same was rejected on the ground that the first additional has no power to pass such an order. The court, by order impugned, has allowed the memo, and by exercising the powers under section 4(2)(c) of the family court, the matter is reallocated to the first additional principal judge family court to be disposed of along with MC number 106 of 2024. And both the parties were directed to appear before the court on 22/3/2025. Learned counsel appearing for the petitioner submits that the first case is instituted by the petitioner, that is criminal miscellaneous, before the principal court, and later the respondent has filed the MC before the additional court, and the petition that is filed by the petitioner is at the fag end of the trial, and at this point of time, transferring this case to the first additional is not appropriate. As well, the principal court ought to have transferred the case that is pending before the first additional to the principal court. When this matter came up on 1/7/2025, this court had directed the registry to place before the court the pendency of the first additional and the principal judge. Looking at the pendency, the first additional has less pendency compared to the principal court. The main petition MC is pending before the first additional court. And the principal judge, family court, for the convenience sake and looking at the matters that are pending, has taken a decision to transfer the case from the principal judge, family court, to the first additional. This court do not find any reason to interfere with that order. If the matter is at the fag end, that will be carried forward by the first additional from that stage, and that would not make any difference, a difference, and no prejudice is caused to the petitioner. Accordingly dismissed.
Cell number 19. Akash Rao for petitioner.
For the petitioner, for the respondent in this case, challenging 125 proceedings.
I not issued the copy.
No notice is issued, it's a fresh matter, is not on caveat.
Is there some CP number so and so?
No, my lord, it was not notified when I was complying with the office objections. It was not notified.
It's there.
It was not notified.
What is this called now? What is this item? 19. No, his name is also there.
He's filed his wakalat, my lord, but there was no caveat which was filed.
What is interim order?
Interim order under section 125 has been challenged only on the limited ground, my lord. This is the second round of writ petition which has been challenged before this honorable court. The first writ petition order which was challenged because of the fact that they are not produced the bank statements. Without producing the bank statements, an order was passed directing me to pay a rupees of 35,000 from the date of IA. This honorable court, it was disposed before your lordships, produced an order, which is page number 159. Next year, N, my lord. This honorable court disposed of the matters.
For the husband.
I'm for the husband. This honorable court disposed of the matter stating that all the bank statements have to be produced and directed
Order
the learned.
Passed in so and so is set aside and the matter is remanded back to the trial court. The trial court strictly in compliance with the law laid down by so and so, and the wife and husband shall pass a reasoned order. The husband shall continue to pay maintenance of an amount of rupees 20,000 per month, and he shall file a memo before the trial court about how much amount he has paid. If any amount is pending from the date of petition till today at rupees 10,000, it shall be deposited within 1 month from the date of receipt of the order, or else the defense of the husband shall be struck off. He shall continue to pay an amount of rupees 20,000 till the IA is decided. The application shall be decided by the trial court within a period of 3 months. Both the parties shall cooperate and unnecessary adjournment shall not be granted. All the family courts are directed to strictly adhere to the judgment.
After this, my lord, the learned trial court reconsidered the maintenance application.
For how much is granted?
35,000 is granted, my lord, from the date of.
Please tell the court.
Please.
As per the order passed by this court, were you complying with that?
It's compliant, my lord. As per the order of this of the learned trial court, the arrears stands at 11,55,000, my lord. But the fact remains is I have already paid an amount of 5,88,000, which is not considered in the impugned order.
7 is pending, 7 lakh something is pending.
That's not been considered in the impugned order is my grievance, my lord.
No. What was the order of this court?
This order.
Relying on this order of 159.
That's been compliant, my lord. That's been
compliant. I said, what is that? Please come to the operative portion of the order. What this court said was, it come to point number 3.
The husband shall. I completely agree, my lord. The fact is, when I've already paid 20,000 from the date of IA till the order was the latest order was passed, that's not been considered is what my grievance is, my lord. I'm again made to pay 35,000 from the date of IA. The date of IA is July 2022. This honorable court directed me to pay 20,000 from the date of the IA till the.
How much it comes to?
Now, my lord, now as per the latest order, it comes up to 11,55,000.
Latest order.
Please.
As far as this order is concerned,
please.
From the date of order till the case is disposed of,
please.
You were directed to pay 20,000. How much it comes?
Somewhere around 4 lakhs, my lord. Now, my lord, the tune of 5,88,000 is already paid. Now I am again made to pay 35,000 from the date of IA. That's what I am agreed with, my lord.
How can it be?
He's earning, he's earning, your lordship. His salary is more than 2.5 lakhs. And I have a kid, I am staying in a rented house.
My lord, I'm not even disputing about the quantum of the maintenance which has been
Including,
ordered.
I have to pay
I'm again made to pay 35,000, which out of which I've already paid 20,000. And half of the maintenance amount, the arrears amount is already paid to the respondent.
let him file a memo of calculation, your lordship.
No, what will happen is, now, this court has directed you to pay 20,000. If the court grants 35,000, then remaining 15,000 you have to pay.
That I'll pay, my lord, out of which, that's what, the whole concern is this, my lord, 11,55,000 is the arrears.
No, instead of, calculating in the air, when is the application filed?
Application is on 30th of July 2022.
1 minute, 30th of July?
2022.
July 2022.
Please.
So, from 30th July, when is this application decided?
This is the present application, impugned application is there on 25th of April.
25th of?
April 2025.
25th April
2025.
2025. So, as per the order of this court, from 30th July 2022 to 25th April 2025, you need to pay 20,000.
Please, that's been already paid.
Please calculate
Please.
and tell the court.
I'll file a memo of calculation.
Please do that. So what is the memo should contain is from 30th July 2022 to 25th April 2025 at 20,000, how much is the amount?
Please.
Now the court had granted 35,000. 35,000. So what is remaining is 15,000 towards arrears.
Please.
So how much it comes?
Please.
That you have to file a memo.
File a
When?
Any date next week, my lord.
Is this matter next week?
In the meantime, a copy may be served to me.
I'll serve a copy, my lord. The only concern is 4th of
Any
July, it's
objections,
coming
I'll
before
file
the
any
trial
objections.
court. Let him not precipitate on the IA, my lord. Until then, that's all.
When is
I
it
have to-
coming?
4th July.
No,
Including-
so why can't you file 4th is Friday?
4th is Friday, my lord.
File tomorrow. Tomorrow is Thursday.
Client is not in town. That's the whole concern. my
Next
lord.
week,
Have
maybe
it on
maybe-
Monday, my lord.
Next week, my lord.
Monday, not Monday. Monday there are so many matters. Tuesday.
Grateful.
Obliged.
Let him not precipitate the matter before the trial court. That's the whole concern.
Direction to serve the copy, my lord.
I'll serve a copy today itself.
What is there to precipitate? List this matter on Monday. The petitioners to serve the copy of the memo on the council appearing for the respondents. Yes. Huh? Tuesday. That list, I think.
Great.
Yes, next.
Cell number 20. Siddharth, we move 20.
This matter, the application for interim custody, my lord, has not been considered. The facts are, my lord, that the
Please come to the impugned order.
Yes, my lord. The impugned order is operative portion is at page number 52. Reasons portion.
I number 3 and so and so filed with the petition is rejected. Respondent is permitted for. Who is the petitioner?
Lord, petitioner is the father of the children, minor children.
Father is rejected. Further, the respondent is permitted for visitation of the children. Children are with whom?
Children are with the mother, with the maternal aunt. The mother has passed away. What has happened, my lord, is the petitioner is the father. The husband and wife, there's a divorce proceeding filed. Initially, my lord, criminal case was filed. That was, my lord, they were compromised. Thereafter, a compromise petition was filed. That annexure I have mentioned. Then, my lord, the children were with the mother of the. After which, my lord, she passed away. The children have come.
The mother passed away.
My lord.
In which year at least?
2020, my lord, she passed away. 2022, my lord, 2022 she passed away. 18/11/2022.
What is the cause of death?
Please, my lord,
What is the cause of death? Suicide.
No, my lord, it was death, my lord, with, there's no, my lord, any mention about the reason. My lord, suspiciously, my lord, she passed away. She was living with, my lord, the respondent who's the sister and the children she was living. Thereafter, my lord, the father.
As on the date, they both are divorced by the.
Divorced, my lord. I will, my lord, point out the operative portion of the, my lord, settlement agreement. My lords will have a settlement agreement at page number 74, annexure K. This is the settlement agreement, mediation agreement before the family court. That is the wife and the husband. And thereafter, at para number 76, page number 76 may kindly be seen. Number 7, both the parties have agreed their valuable articles and personal belongings. both parties hereby agree that maintenance of the children shall be taken care by the petitioner. If any unforeseen thing happens to the petitioner, the respondent father will get the custody of the children. Is specifically mentioned. Thereafter, the father requests the aunt, that is the respondent, to hand over the custody of the children.
MCs of which year? This
This
GNWC of which year?
GNWC, the aunt files a petition, which is filed in the 2023.
She files the
She files a petition. I file a counter claim. In the counter claim, I am requested for appointing as a natural guardian as well as the custody of the children. In that, I file an application for interim custody. On the interim custody, the learned court has passed an order saying that interim custody cannot be given, but visitation rights has been given. I am on the thing for the visitor.
What is the age? Age of
age? One is born in 2012, and one I have mentioned the dates.
No, they are aged now.
They are aged 13 years and 8 years.
Both are girls.
The elder one is a girl, younger one is a boy. And now the custody with the respondent aunt, and she's about 50.
They're staying with the aunt from 2018.
No, 2022. 2018 was a petition. 2021 was a divorce. 22 she passed away. The mother passed away in 2022.
So from after the divorce, they're staying with the mother, with the aunt and the mother.
Please. And thereafter, after 2022, when the petitioner approached the aunt to hand over the custody, there was one false criminal case also filed. That was in a B report. A false SC/ST case also can be registered. While she was dead, I'll also show the conduct of thing. I may kindly turn to page number 81, where there is a thing that the Preeti, who was wife, she's shown to be married. I may kindly see two certificates have been produced at page number 81 and 83. 81, it shows as the bottom date may kindly be seen 8 September 2022, and on page number 83 it is shown as 8 December 2022. By the second certificate, she was already dead. She was not even alive.
No, please come to the impugned order.
Impugned
What are the
order.
reasons that are given?
Please.
While rejecting it.
He says, that that they are with them, and they are more accustomed to that. Page number 52, the operative portion starts. The above petition, page 52. Above petition is filed to appoint the petitioner, who is the elder sister of the minor children, mother as a guardian. The mother of the kids by name Preeti expired on so and so. The application is filed with the respondent.
Please take out notice. Once they come, we'll see.
Could it be emergent notice, please?
Take out hand summons. Hand summons to the counsel appearing for the respondent and shall file a memo to that effect. Once the memo is filed, list the matter.
And even through emergent notice also, I'll take both methods. Sometimes the councils will
issue emergent notice also.
And could it date period fixed?
The moment you file it, it will come. That's what I request.
Cell number 21 adjourned. Cell number 22.
21. I pay for 21.
21, where it
I am
is
for
adjourned?
petitioner.
What is over is 20? Call 21.
As for the respondent, your lordship.
$22 is adjourned, not 21. Yes.
The impugned order dated 8/1/24. The claim petition filed by the wife, that is first petitioner, has been dismissed. And the son's claim petition is partly allowed, thereby ordered to pay a sum of 3,000 from the date of filing to order.
Where is the impugned order?
Impugned order, page number 10, my lord. Last para 25, my lord.
Why it is rejected for the wife?
Wife, my lord. Wife is she's housewife, my lord.
Why it is rejected? Which paragraph deals with that?
Well, at the trial court in page number 24, my lord, in the judgment, in reason number 23, para number 23, that the petitioner is having an illegal intimacy with the sister's husband of the respondent. That is the allegation here.
This is the finding. Come to the discussion. Which paragraph it is discussed?
Para number.
Here, the paragraph
16. Come to 16.
16, Miller.
Please read.
But here, in order to prove the said contention of illicit relationship, the respondent got examined R2, who is the close relative of both the parties. He is son of the maternal uncle of the mother of the first petitioner of the respondent. He has deposed that he came to know about the illicit relationship through the respondent, and this regard several panchayats were conveyed, and the first petitioner was advised, but she did not mend her behavior. In the cross-examination of this witness, the petitioner's counsel tried to elicit that he is not personally aware about the said allegations. On perusal of the affidavit filed by the examination chief R2, he has stated that he came to know about this illicit relationship through respondent.
Who is respondent?
Respondent is husband, my lord. Respondent is husband. Coupled with my lord, he also deposed before the trial court stating that he is having a documentary evidence, videographic evidence, but not submitted before the trial court. In the cross-examination, he clearly admitted.
How can the court decide all this in a 125 CRPC proceeding? And the witness, whoever states that, he has come to know from the husband himself all these things. And how can that be taken into consideration? Counsel for the respondent, I'm referring to you.
Sorry, Your Lordship. Your Lordship, no doubt that during the course of cross-examination as well as during the matter which was taken earlier, even today I am ready to take her as a wife, Your Lordship.
What about the any MC proceedings are pending?
MC
No.
is not.
Then why is the wife not joining the husband?
No, but mediation held. He didn't appear before the mediation.
No, we will. He says.
No. Sorry, Your Lordship. I appeared before the mediation. And mediation was held. And a mediation was held.
That he is ready to take back the wife, and it is.
Yes, Your Lordship.
Counsel for the respondent that the wife is ready to join the husband. Both the parties shall appear before the. Where are they in Bangalore?
Bangalore, thrice.
They are from Kolar.
Center on.
No purpose will be served.
7th of July.
No purpose.
This matter, and if the parties fails to appear on this on the day, the matter shall be sent back to the court, and immediately shall be listed.
Because my lord, 3 occasions he appeared.
Mr. Counsel, when you say that she wants to join, when he is ready for the sake.
No, my lord, I never
disposing
said
of the
that.
case,
She is not ready to join because he made
saying
such an
that.
allegation.
He is saying.
But my lord, in the mediation, he didn't appear.
No, I appeared, Your Lordship. I appeared on 3 occasions. Out of 3 occasions, 1 occasion I was not keeping well. On 2 occasions, I was present, Your Lordship. Mediation report can kindly be looked into, Your Lordship.
Please go to the mediation on that day. Otherwise, we'll pass orders on the merits.
Cell number 22,
Yes, sir.
23 urgent. Cell number 24, Deepa J for petitioner. Please not the vote.
I pay for the.
What was she saying?
They made some allegations in the air.
Actually, ರಾತ್ರಿ ಎಲ್ಲ ಮಗು ಆದ್ರು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಬರುತ್ತೆ. ಅವತ್ತು ರಾತ್ರಿ ಬಂದಿದ ತಕ್ಷಣ ಮಗು ನನ್ನ ನೋಡಿದ ತಕ್ಷಣ ಓಡ್ ಬಂದ್ಬಿಟ್ಟ ಪಾರ್ಕ್ ಅಲ್ಲಿ.
English.
Okay. When he saw him, he ran away. When
you can tell.
What she says is that, my lord, when as soon as that time when the father was getting the child in the park, as soon as the child sees her, he ran away to her and he came to her. That's what she's saying. And apart from that, my lord, in the midnight, what she says is that in the midnight he wakes up in a fear and says that don't beat me. What she feels is that the child, any of my lord, the children.
You could have asked the child also, why are you saying that? What has happened? What, anything went wrong?
That time he won't tell anything, ma'am.
Why will he not tell?
That's what.
If something, no, if he's getting a bad dream, not necessarily that it should be because of father.
Well, that 3-4 days, continually, that was happened. That's what she's telling.
How old is he?
3.5 years.
Why would he not tell? The children will say that when they have any problem, they will tell. That means that he has no, it's not from the father. Immediately, particularly in this kind of strained relations, all the more they will tell that father did this and that.
No, the child has not told anything. That's what.
So let her not assume that.
My lords, I'm producing one pen drive and I'm going to show the video with your lordships. On the day when the child was dropped, the child wanted to spend more time with the father, and it is recorded in the video as to how the child is comfortable at the house. In fact, with date and time, including the subsequent visitations. This overnight that they are mentioning is on 13 and 14. Post that, there has been 2 visitations that has taken place on the 3rd week and 4th week as well. And I am producing videos of that as well to clearly show.
That's what I submitted. Last time I
Both of
wanted to make
let
it
both
as a,
of them not make it so complicated.
That's what
the
I
boy
told.
is comfortable. Let any of them show to the court that the boy is more liking to be with the father more or with the mother. Whatever it is, still the court will pass an order granting them their equal whatever entitlement they have. So please come to the order. What is the order passed by the?
My lords, there are 2 writ petitions that are, you can sit.
Give the other writ petition also. So let's see the first writ petition first. WP 26399.
That is a challenge which the respondent wife has done in respect of an order that was passed by the family court in terms of visitation.
No, that is filed by you.
That is the maintenance, my lord.
26399 is filed by you.
That is in respect of maintenance.
So let's
There is
see
one
that.
more which is 25582, which is the
No,
first
let's
one.
see 20 because it is there
Well,
before the
it's
court.
26399 is a writ petition filed by me challenging the maintenance order. Well, it's due to huge number of criminal cases. I being a specialized AI related engineer, and I was working in a company, and thereafter I lost my job.
First of all, let me look at the
Order,
order.
my lords, if your lords may kindly have, the order is at ink page 13.
Yes.
The operative portion, and the operative portion of the order is at page 14, where it says the respondent father is directed to pay monthly maintenance of 20,000 to his minor son from the date of the filing of the IA, that is from 27/1/2024, pending disposal of the petition. The said maintenance shall be set off if ordered in any other proceedings. The respondent is also directed to pay one-time
How much he
litigation.
was paying?
This honorable court, your lordships, had granted an interim order in this for paying 10,000, which I am judiciously paying. Along
So now
with
whatever
this,
that is paid, that will be set off, it has to be deducted from this 20,000. Whatever that is paid, it has to be deducted.
yes, my lords. My lords, we have come before this court because we are unable to pay this 20,000,
What's
and
his salary?
therefore, my lords, he is unemployed for the last 2 years. In fact, he is looking for the jobs, and there's standard emails, even he has cleared the jobs. In fact, on the last date of hearing, I have filed a memo with documents where I have produced the documents that he has cleared interviews, but he is not able to get the job. Ultimately, when they do a background check, because of the FIR that is being filed, there are 2 FIRs that is being filed by her against him. And because of those, he's not able to get through. And this is not just any engineering, he's specifically into AI. And they deal with foreign clients. So none of these companies wants to take when the father has this issues. My submission before this honorable court is, whatever is being ordered as an interim, it may kindly continue. The day I get the offer letter, I will myself produce before the court, and I will, the first salary slip I'll produce before the court. And based on that day, whatever is the maintenance that is required for the child can be done. Here is a case where the wife is earning and maintenance is not for her, maintenance for the child.
How much is earning?
35,000. 35,000.
So it is for the child. In fact, the mother in between.
What are the cases that are pending as of now?
My lord, one is a DV case, one is guardian.
No MC.
No MC.
Without that, they want to fight all this.
That's what they're doing.
By the,
Then there are criminal cases of 498A and
the
also
wife wants to join, or
My
what?
lord,
Why she is
actually,
not
my
filing
lord,
the?
when the Justice Pradeep Singh, when he has interviewed both the parents, my lord, they were ready to join. The only condition is that he has to set up a separate house. He had agreed.
Who has agreed?
Husband had agreed.
Then what has happened?
But thereafter, we don't know, he is not ready now
What has
again.
happened to them?
So, my lords, her demands increases every single day. First of all, there is an allegation in respect of she having a relationship in the past while in the matrimonial relationship. So he's asked to cut all the ties in with that person. That is one. Two, he's told, because I am unemployed for few months, we'll have to manage. The moment I will make sure once these cases are over, I'll make sure that I get my job and we will set up a proper full-fledged house. She wants him while he is unemployed to set up the entire house, to make sure that he plays completely. In fact, my lords, what she had done is she had put the child into an anath ashram and not a daycare center by paying just about 500 rupees as the monthly fee. He said, why are you doing this? Therefore, what he had made sure is that the child right from the beginning goes to a good school. So he ensured that he communicates to her and started looking for good school. The school that the child is presently going for preschool is Kumaran School, which is just about 10 minutes away from both their houses. He ensured that the fees of that is also paid, because he knows that she can put the child again into some anath ashram or to some school which is absolutely not good. Therefore, he had also paid the fees and he asked her to set off that fees which is paid, which is 1,20,000 to the maintenance, which that also she is not ready to do. That's been the conduct. So he said, in fact, that 1,20,000 also, he had to redeem whatever little mutual funds that he had, which he had it for the last 10 years. He had to redeem it to make sure that he has to pay the school fees. He is only living on a savings as of today, and which is also got over, and because of which he had to pull down his mutual funds as well.
He paid 1,20,000 towards the school fees.
Yes.
Yes, madam. That is why I am not disputing it. My lord, let me submit, madam.
That
The first and foremost thing is that, my lord, the company has not removed him from the job. My lord, he voluntarily resigned. He has produced those documents before the.
When he resigned?
My lord, after all these proceedings have started.
That is
Intentionally.
2 years back.
Yes, madam. Intentionally has resigned. And he has threatened her saying that I will not even pay one single rupee. My lord, he was getting about 1,47,000 rupees was his salary. My lord, when the matter had come up before this honorable court stayed directing him to pay 10,000 rupees per month. My lord, and further this honorable court on 26/9/2024, because I have brought to the notice of this court that he had 50 lakhs in his account. He has transferred that in the meantime, and then he started claiming that I don't have money. Then
To whom he has transferred?
His mother and some fixed deposits and all. Then when I brought to the notice of this honorable court directed him to file an affidavit stating that from whom he has borrowed that money, because he claims that I borrowed the money from my mother and brother. And that as such this court has directed, you produce the documents to show that from whom you have borrowed the money and whom you have transferred. But he has not produced any document to show that he has borrowed the money from his mother or his brother. That affidavit is there before this court. He has suppresses, but because the entire amount because this amount, that 50 lakhs, what he has got it is that he had entered into an agreement to purchase some property with some third person. At that point of time, he has paid this amount to that lady. Thereafter, a cancellation deed was executed. From there, after the cancellation, that amount has been returned to him. All this has been taken by way of check transaction itself. The entire amount came to his account. After that, he has made fixed deposits in his name only in the same bank. Thereafter, he has cancelled those fixed deposits after this proceeding started, and he has transferred that amount to his mother. That was brought to the notice of this court. This court directed him to produce the document saying that from whom you have borrowed, you please give the documents. He has not given those documents before this court. He has income. He is getting interest from his bank. Own bank statement shows that he is getting interest, and also some mutual funds he is getting this thing. And what he is paying is the court has ordered only for the maintenance of the child, because I started earning only very recently, about 8 months back. I am getting 35,000 rupees salary. I have asked only for the maintenance of the child. This court, the family court, granted only 20,000 rupees. This court directed him to pay 10,000 rupees in the meantime during the pendency of this proceedings. What he has done is that till April he has paid 10,000. Thereafter, he has paid 1,20,000. I do not dispute that because he wanted the child to join the school. I said, okay, as your wish, I'll come. He has paid that fees and he has the school, the child has been joined to the school. Now, what he sends the message is saying that as for 10,000 rupees, I'm not liable to pay from May 2025 to June 2026 because that whatever the 1,20,000 rupees are paid to the school, I have to adjust. This is what is now sent a message. In that 10,000 also, that's what he states. When he has income, he wants this child's custody. Every time we are sending the child without any this thing, everything. But only thing for the coming when it comes to the maintenance of the child, he doesn't want to pay.
Yes, what about?
My lords, in respect of this.
No, John, what about that,
50 lakhs.
Not 50 lakhs. What has happened before Justice Arun and now
My lords, Honorable Justice
where
Arun,
it stands now?
Yes, ma'am. Honorable Justice Arun made a complete mediation session. He spent more than 2 hours to talk to the parties. He did know that there are differences, and my client also mentioned about the extramarital relationship and other things. Justice Yarur advised, see if you can patch up and live together, and thereafter they said you have communications. My lords, my client starts communicating with the wife. She has her list of demands that I will not live in that house. You should not meet your mother. You should set up a house and you should take care of the complete expenses. I will not contribute 1 rupee for it. These are the statements. My lords, I have produced those messages before your lords through a memo in the list of documents. In fact, in that, all the WhatsApp chats also I have produced. This has been the issue. And my lords, in respect of when the meeting happened with Honorable Justice Yarur, lordships found out that the child is more comfortable with the father than the mother because the child was non-stop. Yeah, they increased. 1 second, my lords. May I kindly?
That will happen.
Your lordships, they had increased the visitation as well. On that day, an order has also been passed.
What she says about what are her demands, why she is not joining the husband.
Now she is not ready.
No, she's not ready. Sometimes he's not ready. Or you don't want to stay with your. Now he's not earning. Whatever you're earning is only just 35,000. In that, how can he set up a separate house? How do you expect him to do it now?
ಅವ್ರಿಗೆ 35,000 ಸಂಬಳ ಬರ್ತಿದೆ ಅಷ್ಟೇ ಅವ್ರಿಗೆ ನಿಮಗೆ ಅವ್ರಿಗೇನು ಕೆಲಸ ಇಲ್ಲ ಸಂಬಳ ಇಲ್ಲ ಹೆಂಗೆ ಸಪರೇಟ್ ಮನೆ ಮಾಡಕ್ ಆಗುತ್ತೆ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ.
No, till he gets a job, why don't you stay along with the in-laws in that house?
There are some allegations against the mother-in-law, my lord, which I don't want to say
How
before.
many days they were together?
My lord, 2 years, 1.5 2 years.
So you don't want to join your husband? You don't want to join your husband, or on conditions you want to join?
No, I don't want to join.
Even all those conditions he fulfills also, you don't want to join?
Even I have after coming out of his house, even I have tried so many times, even I tried to contact his friend, but he's not ready.
Then we'll pass out.
Well, it's this maintenance that was ordered for 20,000.
What about that 50,000? Where is that?
That is not 50,000, 50 lakhs, ma'am.
50 lakhs, what
My
happened?
lords, at an undisputed point of time when the marriage was happy, they entered into one sale deed, one sale agreement of a property to purchase in the name of the petitioner where the family members had contributed at an undisputed point of time. Later, what happened?
How they have contributed?
Yes, my lords. I have filed one clarification affidavit on 29/11, my lords.
In which case? In which case?
In
26399 only.
26,399.
Yes, my lords.
13/9/2024.
Yes, my lord.
Yes, my lord. 29/11/2024, a clarificatory affidavit.
29/11. Yes, it's there.
Along with that, I have also produced the sale agreement And I have produced this cancellation of the sale agreement as well.
Page number?
My lords, cancellation is at page 15, which is annexure B.
I don't think so. It is transfer of amounts, I think.
My lords, this is how it looks.
It is 29/11/2024 is the one.
Yes, ma'am.
List of document along with documents.
Yes, my lords.
No, my lord.
So it's not
Clarification-
list of
clarification
documents.
affidavit.
Clarificatory affidavit only I have written, my lord.
Yes, clarification.
If your lords may kindly have, she moved out of the matrimonial home in 2023. This agreement was in 2020 and the cancellation is also in 2022. My lords, that also they had to file an FIR to get this amount back because they were not registering, the seller was not registering the sale deed also. He was also not
That is
giving
one
back the money.
aspect. No, that's one aspect. You have to tell the court that 50 lakhs.
Yes.
How the family members have contributed.
Yes,
They must
I-
have contributed from some.
My lords, I was a little hesitant to produce the mother's bank statement because it was her personal statements, but I am now producing it and I'll show how the mother has contributed with all this money. If your lords may kindly have this.
Yes.
My lords, on the top, Shashank is the person. They have withdrawn money and she's withdrawn for Shashank 80, 2424, 2,25,000, 2,50,000. This is on 2020. Shashank is the seller. My lords, another transaction, if your lords may kindly come to 6th page, my lords, 27/8/2020. 7/8/2020. She's done RTGS to Shashank, 4,70,000. And thereafter, my lords, another transaction on 15/10/2020. Sent RTGS.
15/10/2020.
Yes, my lords. Last page, my lords. She sent RTGS to Shashank on 20 lakhs she sent. This is not his money. And my lords, in respect of me getting the money and transferring also, in fact, my lords, the assets and liabilities of the parties are not produced before this honorable court. May I be permitted to submit the assets and liabilities? I have already produced in that statement, my entire statement. There's nothing that I have suppressed. In fact, the wife.
Now, all this amount, if you count, it comes to around 30 lakhs.
Yes, my lords. And
what happened to the other 20 lakhs?
my lords, the other is by the father and the brother, and even petitioner has contributed. Petitioner has also contributed meager amount of 5 lakhs. I have a write-up of this whole thing. The brothers, we could not get it. The brother is in another country, my lords. If your lords can see in this assets and liabilities that I have produced now, my lords, I have already put that statement as well.
Give him a copy.
My lord, no, my lord, one submission.
That's an assets and
From where this Shashank came, if your lordship may kindly see, the agreement is with one Nanda. Where is this Shashank? The agreement is with one Nanda.
My lords, Nanda is the mother of Shashank. Mother is the holder of the property, my lords. Shashank is the son who is dealing with all these properties. The agreement holder, I have the document, my lords.
If your lordship may kindly see the agreement, it has been transferred from his account. It has been clearly mentioned by RTGS.
It is not, my lords. I'm showing the RTGS statements right before your lordships.
No, without further going into all this. Now the father is paying the school fees.
Yes, ma'am.
We'll direct him to continue the taking care of that.
All
And
educational
with-
expenses.
and the school fees, and the 10,000 will do.
My lord, 10,000 will very well just make up because
No,
my
if
lord,
you-
van charges.
Please understand.
Van
No,
charges.
No. 1,50,000 is the fees he has paid.
1,20,000.
20,000. How
Yes.
much it comes per month?
10,000.
10,000.
Yes, ma'am.
Already there is an order by this court to pay 10,000.
Yes, ma'am.
Put together, it comes to 20,000.
20,000.
There is no order from the court to pay the school fees.
My lords, this
That time the child
20,000
not
was
going to
for
the-
school.
It was not there.
That time the child was not going.
So we'll continue him to pay
Sir,
the.
that 1,20,000, as per their affidavit, whatever they have filed it now, my lord, it's only one time, this thing is only 65,000. The school fees, another 60,000 is the only yearly this thing. That one time is only will be paid only for the initial at the time of joining. Next year, it won't be that much.
What it would be next?
It will be 65,000 rupees.
No, my lords. Every
That's
year,
what they
my
have
lords,
stated.
every year it is going to be increased. And my lords, this 20,000 was ordered for the child itself. My humble submission is, I will give 5,000 for the maintenance because most of the days he's also with me and I'm giving all the requirement for the child also. I may be permitted, my lords.
5,000.
My lords, let there be an order where the moment I get the job and I will ensure that I bring it before the court. Here
the
is a
job you're
case
doing
where
so
the
many
mother
things.
is suppressed facts about her job in the assets and liabilities. That was the condition. In fact, there is a perjury application that has been filed. Summoning of the document has also been filed.
That you can carry forward. Please come. Agreed with the orders passed in.
My lords, it will be too difficult for the father to make such a huge payment because he's unemployed and he doesn't even have that kind of savings, my lords.
No, he was continuing to pay 10,000 and nobody asked him to pay 20,000. 1,20,000. He paid. That
My
means
lords,
he's having the.
because I have produced before this honorable court that she put the child to an anath ashram. My lords, that's the reason. My lords, I do not want to make allegations now.
No. Now you've joined him in a school and paying 1,20,000. You will continue it, is it not?
My lords, that's what. I'll continue.
And 10,000 you have volunteered to pay and you are paying.
My lords, that 10,000 at this point of time, only at this point, I'm being very specific. It may kindly be recorded in the order sheet. At this point of time, I'm having too much of difficulty with that 10,000 because he has to run around 5 courts for 5 different cases as well as paying this 10,000. He had to literally take from people and pay this 10,000. Even the school fees also, whatever the little mutual funds that was left out, he had to redeem that. And I've produced document to that effect also. That's the condition. All my submission is, kindly give me a year's time. I will ensure that I make my job set. And based on my salary, this honorable court can.
Then after years time also, those cases are not going to be closed, all criminal cases. As you're saying that because of the pending cases, he's not getting a job. So he won't get a job.
My lords, we have applied for quashing. We have applied for the quashing of the FIR and we are, my lords, kindly. There is some hope in that. And therefore, in fact, one matter is stayed. There are 2 matters. In that, one matter is already stayed. Therefore, my lords.
Agreed with orders passed in I number 3, I number 8, whereby the court had granted 20,000 maintenance to the minor son from the date of filing of IA, that is from 27/1/2024 till disposal of the petition, and also litigation, on-time litigation expenses of 25,000. The father is before this court. Land counsel appearing for the father. The parties are referred to as father and mother for the sake of convenience. Land counsel appearing for the father submits that the father is unemployed as there are criminal cases pending against him and his specialization is in the artificial intelligence and is applying and he has the openings in multinational company as there are pending cases against criminal cases against him, he is not able to secure the job. This court has directed the father to pay an amount of rupees 10,000 in the earlier round of litigation pending disposal of the application for maintenance, and the father has been paying the same. It is submitted that the mother has joined the child in an anath ashram, in an orphanage. As such, the father has to take the initiative to put him in a good school, and he has paid an amount of rupees 1,20,000 towards the school fees. It is, yes, for that, he has to redeem the mutual funds which were there for a long time, as he is not having any other source of income. Then counsel for the petitioner submits that once he gets employment, he himself would come forward and will pay the amount, will pay the maintenance, and at this stage it's difficult to pay the said amount, and the husband he'll be comfortable to pay an amount of rupees 5,000 per month as maintenance, and he would be taking care of the educational expenses. I should record that. He should be taking care of the educational expenses. Land Council also submits that the wife had suppressed the fact with regard to her salary, and they've already moved a petition before the court, and the same is pending adjudication. It is submitted that the amount that is granted by the court needs to be reduced to 5,000. Next one. Land Council appearing for the respondent mother submits that the is in fact an amount of rupees 50,000 that was there in his account is transferred to his parents and other family members. And in fact, the job which he was having when these proceedings had started, he himself has resigned the said job. It is with an only intention that he'll not pay the maintenance to the wife. It is submitted by the wife that the husband, Land Council submitted that it is the husband who has taken a decision and joined the child in the school, and he is paying the maintenance, he paid the school fees. It is submitted that with the amount of 35,000 which she is getting as salary, she has to take the house on rent, and also she has to bear all the expenses. And the family court had rightly granted an amount of rupees 20,000. If the same is reduced, it would cause a lot of hardship to the mother taking care of the necessities of the child. Next, in response to that, Land Council appearing for the husband submits that, in fact, when they wanted to purchase the property in the year 2020, it is the mother and other family members who have contributed. When they have cancelled the agreement of sale, the amounts were returned to the family members, and in fact, the contribution from the father is only from the petitioner is only 5 lakhs, and the submission that the amounts which were lying in the bank account only for the purpose of evading maintenance, they have been transferred to the other family members is not correct. Next part. Having heard the counsels on either side, peruse the material on record. In the earlier litigation, when the matter has come up before this court, and the father had filed applications for visitation, this court has passed order. This court has issued directions, and the visitation was granted to the father. At that point of time, this court had directed the father to pay an amount of rupees 10,000, and he is paying an amount of rupees 10,000. When it comes to joining the child in a school, whatever are the reasons for the father to join him in the school, as this court at this point of time cannot go into the aspect that whether what are the lapses on the part of the mother, whether she has joined the child in the orphanage or not. But the father has taken a conscious decision, and he put the child in a school where the fees is 1,20,000. The father, it shows that he was comfortable to pay the set fees. Whenever a person wants to, anybody, if he wants to join the child in the school, they would be joining them in a school basing on their financial capacity. And in this case, the father has taken a decision to put the child in a school where he is getting an amount or where he has to pay 1,20,000. And in those circumstances, this court is not in a position, this court cannot believe the version of the father that it is difficult for him to pay the maintenance to the wife. Then coming to the amount of 20,000 that is granted by the court, already when the father is paying the educational expenses, in the considered opinion of this court, an amount of 20,000 that is awarded by the court is on the higher side. And this court deems it appropriate to modify the order passed by the court, reducing the maintenance from 20,000 to 10,000.
My lords, kindly,
My lord,
my
yeah.
lords, that 10,000, honestly, my lords, at this point of time, that's what I'm trying to tell your lordships, that whenever it is, even on that point of day, he is earning 3 lakhs. According to that, maintenance can be ordered.
Why did
At
he,
this,
why did he join the boy in a school?
my
where he
lords,
has to pay
my
1
lords,
lakh?
because it is convenient for both the parents. The school is just about 5 minutes away, and it is one of the best schools, my lords.
Next matter.
My lord, let there be a direction, my lord.
And
to
in
continue
fact,
Next matter is different.
My lord, let there be a direction to continue to pay the school fees every year.
And the father shall continue to pay the school fees. Father shall continue to pay the school fees. Next. 24.1. What is the order? In 24.1.
Overnight custody was given on Saturday, second Saturday and Sunday, and fourth Saturday and Sunday.
This is filed by whom?
My lord,
that is filed by the
wife.
mother immediately the following day. My lords, in this,
Please come to the impugned order.
It's at page number 50.
The respondent has filed IA seeking interim custody for 2
at
days
page 30, my
on
lords.
14/8/2024 and celebrating their child birthday. Now the set time has already, so the set IA has become infructuous.
That is a different IA, my lords.
That is separate IA.
Where is that? Page number in 25582.
My lords, you will have your lordships that
At page
order
number
on 26.
my lord.
26.
26.
That's an IA on number 7,
Yes.
filed by the respondent under section 25 of the Guardians and Wards Act.
Respondent husband is entitled to have the interim custody of his minor son
Arjun,
2
2
days, twice in a month, on every first Saturday and Sunday,
Sunday.
and on third Saturday and Sunday.
Yes,
The
my lord.
respondent shall pick up. What's wrong with this order?
My
The
lords,
overnight custody we are challenged. My lord, this court from morning to evening it has been given on the very same day. I'll leave to your lordship.
Yes, we'll discuss this also. The writ petition is filed, agreed with the orders passed on I number 6 in GNWC number 148 of 2023, whereby the court had granted interim custody of the minor son to the father 2 days for 2 days, that is twice in a month, that is on every first Saturday and Sunday, and on third Saturday and Sunday. And the court has observed that the father can pick up the child on or after 10 a.m. on every first and third Saturday from the residence of the mother and drop him back on or before 6 p.m. on the respective Sundays, entrusting the custody back to the mother. And the mother is directed to cooperate, allowing the visitation rights of the father. Land counsel appearing for the mother submits that the boy is aged 3.5 years. 3 years, 10 months. And it is 3 years, 10 months. And the father was having the visitation. And the court ought not to have granted the overnight custody, considering the age of the boy. It is submitted that the boy will not be comfortable with the overnight custody and the mother and the boy are comfortable for the visitation as earlier granted by the court. As such, the order passed by the family court needs to be set aside. The land counsel appearing for the father submits that the boy is very comfortable whenever after the visitation that is granted by the court, when the custody is given to the whenever he has to go back to the mother, he was always insisting to spend some more time with the father, and the father and child have developed a good bonding, are having a good bonding, and to take it forward, the court, they have filed an application seeking the overnight custody, and the court had granted without any basis. Just like that, the mother has come up before this court, and the writ petition and the order that is passed by the court is a well-considered one, and this then the writ petition has to be dismissed. Next part. Having heard the counsels on either side, produce a material non-record. In the earlier round of litigation also, this court had passed orders granting the visitation to the father, and and there is no complaint that the boy is not comfortable with the father. Even when earlier bench interacted with the parents and also the boy, the coordinate bench of this court has observed that the boy is comfortable with the father, and it is also an admitted fact. Both the houses are situated. Both of them are staying nearby, and in those circumstances, there cannot be an objection for the mother for this order of the family court, where the overnight custody of the boy is granted to the father. The contentions that are raised before this court finds no substance in that, and the order that is passed by the court is a well-considered one, and no interference is called for, accordingly dismissed.
But only one submission that the pickup and drop will be near the park, which is near to their house.
The modification, instead of saying that dismissing, the order of the family court is modified to the extent that the father shall pick up the child. The mother will get the child to the park, and from there,
Krishna Rao Park. Krishna Rao Park.
Krishna Rao Park, and from there the father will pick up the child, and then he will drop the child at that place.
Yes. Well, that cannot be done, my lord. That cannot be done. It's my writ petition, my lord.
Let me hear what she is saying.
Second Saturday and the fourth Sunday, the Honorable Justice here, after interacting with the child and the father, gave that order, and he's been exercising that. And also,
that is not. When you are not aggrieved by the order, the mother is aggrieved by the order and she has come, why should we no, if you want to file, no, that's not the way we do it. No. Might be meeting. That is an interim arrangement. Why should we do it now? Yes, dispose of. Yes, next.
Cell number 25. Aditya.
Yes.
Arun Govindraj.
What is the impugned order? What is the impugned order? $39. Petition is entitled for an amount of rupees 25,000 of minor sum from the date of application till disposal of the petition. 20,000. So, on what ground you are before this court? $26. Please read. No, what is your income according to you? 1,21,000 is your income. Wife's income is? 116. 60. Who is living in that house? Huh? And whose name the house is? Oh. So you're contributing 50,000 towards the EMI. And what else you're doing? Mm. Mm. 10,000 per month. Mm. Mm. No, that's what we'll record. So your contribution is, no, you're spending an amount of rupees 60,000. You are left with another 60,000. In that court has directed you to pay? Hmm. We'll read that paragraph which you're upon hearing both the sides. Para 14. What is the age of the boy?
He's about 8 years old.
8 years. Hmm. What is his annual school fees? Which mother is paying?
I'm sorry, my lord. My learned friend must be fair to the court. 8,000 rupees, he says, is investing in an insurance policy for the child. He's not paying the school fee.
Then we'll continue reading from para 14. That 14. Yes, I've seen the order. Yes, Mr. Gondraj.
Lord, kindly see the affidavit filed today, page number 2. He's not paying 8,000 rupees towards educational expenses. He is paying that towards an insurance policy which matures when the son turns 18 years old. Page 2 of the affidavit of assets and liabilities. If my learned friend files an affidavit today, my lord, that he's paying educational expenses, let that statement come on oath.
That may not be correct. That's what it is referring to. Maybe court has recorded it as that.
Page number 2, my lord, at E, details of children of the parties, but column 5, whether any voluntary contribution by either of the parties is being made towards his educational expenses. Rupees 8,000 per month, maturity when Ayush will be 18 years old. It's some fund in which he's depositing. And my lord, his income, I think what is lacking, my lord, is transparency here. My lord, from the affidavit of assets and liabilities, my lord, certain documents I have taken. I'm filing a memo. From me, it's not from the petitioners.
Yes.
Page number 1. In the month of May 2024, page 1, my lord.
The copy of the council.
Pay slip for 2024.
1 minute. 1.
Pay slip for May 2024. Kindly see, my lord, the bonus he's got. It says current month. Bonus he's got is 5,71,000 rupees 200. Salaries at the bottom, my lord, 1,48,000. Lord, before the court, an affidavit is filed that he gets 1,21,000 rupees per month. Lord, kindly see the income tax returns filed by them. Document number 2, next page. 24 lakhs is the annual income for the previous year. Then on the next page, document number 3, my lord. Document number 3, page number 3. This is dated 12th of July 2024. Consequent to compensation benefit revision, consequent to evaluation of your performance during the past year, we are pleased to inform you that effective from 1st April 2024, your compensation in terms of cost to company has been revised to 25 lakhs 80,000 per annum. A detailed breakup of annexure 1. Well, if your lordship will kindly turn over then on the next page. Basic salary, flexible allowance, not per month. What he gets at the bottom is 2,15,000 per month. 25,000 is what is awarded, but not only for the child, and the school fee of the child.
No, how can there be when your salary is 2,15,000? Why did you say that it is 1,40,000 or 20,000?
But one thing I would like to address, in document number 1,
No, but one thing is clear. If this is what is
perjury
statement, then immediately will directly initiate. Please. No. I'm telling you. Please tell your client. If there is something which he has suppressed, then he has to face the consequences. Yes.
the concept of a bonus being part of
Forget about the bonus. We are more on page number 4.
your moral case.
Yes. When a counsel for the respondent has placed before this court the document to show the salary of the father from April from
2024.
From 2024 is 2,15,000.
Affidavit is filed on 31st of July 2024.
Affidavit is filed on 31st July
2020, 3 months later.
2024, and it is submitted that there is suppression and misrepresentation of facts before the court. Learned counsel appearing for the father submits that he'll come up with instructions when? Monday?
Yes, certainly.
Monday.
But I have just one last request. The lordship will kindly see page 17 of the memo I have filed today, page 17. My lord, he went on sending me mails incessantly every night. My lord, the reason for separation was that he has a certain habit that every night he consumes alcohol. Page 17, I had filed an application for protection. He files a memo of undertaking, page 17. The lordship will kindly see page 18, my lord, just the last paragraph. Therefore, I do hereby undertake that I shall not send any email or text messages through electronic communication to the petitioner. Not page 19 onwards, our emails sent every single day around midnight. Every single day. The man has no respect for his own undertaking given to the court. I have not produced about 6 pages. My client instructs me these emails come every night after 11:30 p.m. making all kinds of allegations against her. I will show you in court. I will show your lawyer. All these emails are written after 11 p.m. Despite undertaking.
Get instructions. This on Monday.
Obliged.
List number 2, cell number 1.
Memo is.
for it. I'll pass on a copy.
Where is she?
Milord, she's on the way, Milord.
Kodi, sign.
Then she's also supposed to sign.
Yeah, she has to sign, but let them see through. Based on yesterday's
Take
discussions.
that, let her come.
Yes.
I'll pass the order in the chambers. She has to sign.
Correct, Your Ladyship. Yes.
That's what, give her a
changes. Yeah, let
copy.
them tell.
And once the respondent comes, come to the chamber, I'll pass the order.
And Your Ladyship, this is WP 8683. Now,
whatever, when it comes there,
I request one thing. Again, this was disposed of. There is an IA filed for reopening it. So this is not under parents patriae. This is a matrimonial case. Your Ladyship has to recall and then initiate all these things, Your Ladyship, because this matter was also disposed of.
Let's see that.
Please see. They filed IA number 1. Again, the same logistics, allegations and whatnot. It should not come in the way of the settlement.
My lords, opportunities were given to us to revive the petitions. That's why we have, my lords. What he said is fine.
Let's not go into any kind of argument.
Yes,
technical point.
No, amicably that's being settled.
Yes, my
Still, and in that process, what is to be done, the court has to do.
Yes.
So WP number?
WP 8683. I am the petitioner in that. The husband is the petitioner.
And my lords, a
You
simple
filed
submission.
IA number?
8683, IA number 1 of 25.
Let me look at it.
Because her prayer is to send to mediation, not for revival.
This was filed by the wife.
And wait, where is the order passed in this case?
The final order, ma'am, Your Ladyship, in the order sheet you will get.
Page
It was
number?
disposed of.
Date of the order?
1st September. 1st September 22. 23.
1 minute. What is the order for September 22? Is it in the same case, that proceeding sheet? No, where is that order?
May I pass on? I have.
It's here.
Yes, I have the copy. So this was disposed of with a direction to the trial court on 1st September.
This was where, my lords, there was a suppression of the previously existing MC. So that was where the whole contention was. And the court had given us an option, my lords.
The WP number 8683 of 2022 is disposed of on 1st September 2023. Requesting the 3rd Additional Principal Judge Family Court, Bangalore, to dispose of the matrimonial case, that is MC number 4679 of 2021, with an outer limit of 1 year, and all contentions are kept open.
Now, with all humility on that point, in para 11 of the WP itself, we have stated what is the situation and what is the status of the MC case. So this type of submission should not be done, because we have told two MC petitions are pending. Fees, yes.
I am not considering
Yes,
any of that.
correct,
So
correct,
please
correct.
don't make any
Yes.
submissions. In the writ petition is disposed of. Now, IA
IA
is
1 is filed,
IA is filed.
but the
by
prayer is to send to BMC.
That I can see.
Yes.
IA is filed. That's IA number 1 of 25.
Yes.
Is filed, seeking a direction that the matter may be referred to the mediation.
This was based on the letter written by the presiding officer of the family court, please, my lords.
Let's forget about it. We'll not go any of it.
Yes.
And the same may be reported this court. This court had interacted with both the parties as far as the dispute with regard to the matrimonial dispute that's pending between the parties. They wanted to enter into an agreement and file a joint memo before this court, and they'll come up with a joint memo. In that view of the matter, the order dated 1st September 2023 is recalled.
Obliged.
And the parties are at liberty to file a joint memo before this court, come to the chambers.
My lords, in para 3 and 4, I would humbly pray that this honorable court directs them to give the dates, please, my lords. There are no dates.
We
He
have
says
asked
the-
for
both the
two
petitioner-
weeks to arrange the funds. Your ladyship will direct us on which date.
The
Why
dates,
should-
please, my lords.
Yes,
That's
your ladyship will direct.
You can come to the chamber. Once you sign it, you come to the chamber.
Correct,
There I'll pass
correct.
the order. All you want to submit, then you can submit when I'm passing an order.
Yes, my lords.
Now
That's
only
what-
this order is recalled.
Yes, my lords.
That once you file a joint, once he comes and signs a joint memo, come to the chamber, whatever you want, you can submit, I'll include in that.
Grateful, my lords.
Yes. No, as far as this is concerned, now it is revived. And the other matter, what is that custody matter?
5493
5491.
That will be heard tomorrow, please, my lords. On merits.
5493, list this matter tomorrow.
Along with 34901.
Along with
34901.
901. Again, it's there in the list.
It's there
Yes.
in the list.
Along with that, both of them will come tomorrow.
Yes.
This matter, send it to the chamber, and whenever they're ready, then. Any
Obliged.
signatures?
Very grateful, my lords.
ಇದಕ್ಕೂ rubber band. And then she will come to the trial court with logistics and
along with that ಎರಡು connected ಇದೆ. ಹಾ.
ಕೊಡ್ಬೇಕು ಅದೇನು ಹೇಳಿದ್ರಲ್ಲ recalled, restored ಅದು ಬೇಕು ಅದು ಇದ್ದಿರಾನೇ ನಾವು ಮಾಡಕ್ಕೆ ಫರ್ದರ್
ಇವಾಗ ಕಾರ್ಡ್ ಆಗಿದೆಯಲ್ಲ ಅದು ಏನು ಆರ್ಡರ್ ಆಯ್ತು ಅದನ್ನ ಚೇಂಬರ್ ಅಲ್ಲಿ ಕಂಟಿನ್ಯೂ ಆಗ್ತದೆ.
ಅದನ್ನ ಮಾಡು ಇದ್ರಲ್ಲಾಗಿರೋದು ಡೀಲಿಂಗ್ ಮಾಡ್ಬಿಟ್ಟು ಮಾಡ್ಕೊಬಿಡಿ.
ಆಟೋ ಶೀಟ್ ಅಲ್ಲಿ ಡಿಲಿಂಕ್ ಮಾಡಬೇಕು.
ಆಟೋ ಶೀಟ್ ಡೀಲಿಂಗ್ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಸಿಗುತ್ತೆ. ಫಸ್ಟ್ ಇದು ಮಾಡಿ ಡೀಲಿಂಗ್ ಮಾಡ್ಬೇಕು, ರೀಕಾಲ್ ಮಾಡ್ಬೇಕು. ನೀವು ಫಸ್ಟ್ ಅದು ವೈಟ್ ಶೀಟ್ ಕೊಟ್ಬಿಡಿ.
ಇದು ಇದೆಲ್ಲ ಕೆಬ್ಬಿಲ್ಲ ಮಾಡ್ಬೇಕು ಇದ್ರಲ್ಲಿ. ಅವರು ಗೋವಿಂದ ರಾಜು ಮಾಡಿರೋದು ಇದು ಎಲ್ಲ. ಏನ್ ಕೊಡ್ಲಿ? ಇದು ಫೈಲ್ 1.2 ಇದು ಚೇಂಬರ್ ಕಳ್ಸೋದಲ್ಲ ನಿಮಗೆ ಕಳ್ಸಾ ನಮ್ಮ ಫೈಲು ಮತ್ತೆ ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
ಇದನ್ನ ಕೊಡಿ, ನಾನು ಜಸ್ಟ್ ಫ್ರಂಟ್ ಪೇಜ್ ಇದು ಐ ಡೈರೆಕ್ಷನ್ ಐ ಮಾತ್ರ ಬೇಕು ಕೊಡ್ಬೇಕು.
ಒಂದು ನಿಮಿಷ, ಈ ಫೈಲ್ ಒಂದು ಕೊಟ್ಟಿರ್ತೀನಿ. ಈ ಫೈಲು 54 ಕನೆಕ್ಟೆಡ್ ವಿತ್ 90 ಡಿಲಿಂಕ್ ಇದು 5493 ಡಿಲಿಂಕ್ ಆಗುತ್ತೆ. 9057 ಮಾತ್ರ 86 ಅದ್ರ ಜೊತೆ ಇರುತ್ತೆ.
ಇವಾಗ ನಾನು ಲಿಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್
ಯಾಕಂದ್ರೆ ಇದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಇರುತ್ತೆ 86 ಅಲಾಂಗ್ ವಿತ್ ನೋಡಿ 9057 ಅಲ್ಲಿ
ಈಗ ನಾನು ಜಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ಎರಡೇ ಮಾಡಬೇಕಲ್ಲ. 34901 ಮತ್ತೆ 5493
ಎರಡನ್ನ
ಇದೆರಡು
ಲಿಂಕ್ ಇರೋದು 8683 8683 9057 ಯಾವ್ದ್ರ ಜೊತೆ ಲಿಂಕ್ ಆಗಿದೆ? ಅದು ಯಾವ್ದ್ರಲ್ಲಿ ಆಟೋ ಶೀಟ್ ಇದೆ ನೋಡ್ಬೇಕಲ್ಲ, ಲಿಂಕ್ ಆಗುತ್ತೆ ಅಲಾಂಗ್ ವಿತ್.
ನನ್ನ ಟೈಮ್ ಆಗುತ್ತೆ ಟೈಪ್ ಮಾಡೋದಕ್ಕೆ.
ನಿನ್ಗೆ ಟೈಮ್ ಆಗುತ್ತೆ. ಇದರಲ್ಲೆಲ್ಲ 569789 ಏನೇನೋ ಇದೆ. WP 5493 9979 ಏನಾಯ್ತು? ಏನೇನೋ ಆಗಿದೆ. ಈಗ ಬಂದಿರೋದು 4 ಇದೆ.
8683
8683
8683
ಟೋಟಲ್ 18 ಇಲ್ಲ ನಾನು.
ಇದು ತಗೊಂಡು
ಸ್ಕೂಲಲ್ಲಿ
ಪೂಲ ಸದಾ ಇದು ಪೂಲಲ್ಲಿ ಟೈಪ್ ಮಾಡ್ತಾರೆ. ಇದು ಅವರು ಚೇಂಬರ್ಗೆ ಹೋಗುವಾಗ ಈ ಫೈಲು ಡ್ರಾಫ್ಟ್ ಎರಡು ಬೇಕು ಮೇಡಮ್.
ನಾನು ಕಳಿಸ್ತೀನಿ ಬಿಡಿ.
ಪೋರ್ಟಲ್ಗೆ ಕಳಿಸ್ಬಿಡಿ. ಯಾಕಂದ್ರೆ ಅವ್ರು ಬಂದ್ಬಿಟ್ರೆ ಫೈಲ್ ತಗೊಂಡ್ ಬನ್ನಿ ಅಂದ್ಬಿಟ್ರೆ ಕಷ್ಟ ಮೇಡಮ್, ಅದಕ್ಕೆ ಬೇಗ ಕಳಿಸ್ಬೇಕು.
ಆಗ್ತಾ ಇಲ್ಲ, ಅದೇನೋ ಎರರ್ ತರ ತೋರಿಸ್ತಾ ಇದೆ.
ನಿನ್ನೆದವ್ರಿಗೆ
ಹಾ. ಈ ಡೈರೆಕ್ಷನ್
ಈಗ ಇದು 9057 ಡಿಸ್ಪೋಸ್ಡ್ ಮ್ಯಾಟರ್ ಇದು ಯಾವ್ದ್ರ ಜೊತೆ ಕೆಪ್ಪಿಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡಿಟ್ಟು.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂದ್ರೆ ಇವತ್ತೇ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಮೇಡಮ್, ಚೇಂಬರ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. ನೀವು ರಿಕಾಲ್ ಮಾಡಿ ಮತ್ತೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಿ. ಆರ್ಡರ್ಸ್ ಅಂತ ಆರ್ಡರ್ಸ್.
ಇದು ಏನ್ ಮಾಡೋದು ಅಂತ ಗೊತ್ತಾಗ. ಇದನ್ನ ಯಾವ್ದ್ರ ಜೊತೆ ಈಗ ಲಿಸ್ಟ್ ಮಾಡೋದು?
ಹೌದೌದು.
ಅದೊಂದು ಮ್ಯಾಟರ್ ಡೀಲಿಂಗ್ ಆಯ್ತು.
18 ಇದೊಂದು ಹೇಳಿಲ್ಲ ಮೇಡಮ್ ಏನ್ ಮಾಡ್ಬೇಕಂತ. ಇದನ್ನು ಹೇಳಿದ್ರು.
9789 ಅಂತಾರೆ. ವಾಟ್ ಅಬೌಟ್ 9789 ಏನಾಯ್ತು? ಡೀಲಿಂಗ್ ಆಯ್ತು ಅದುವೇ ಮತ್ತೆ? ಅದು ಇಷ್ಟೇ ಆಗಿಲ್ಲ ನಮ್ಮ ಮುಂದೆ.
ಅಲ್ಲ 9798 ಅಲ್ಲಿ ಏನಾದ್ರು ಬೇರೆ ಆರ್ಡರ್ ಇದ್ರೆ
ಅಲ್ಲ, ಅದು ಡೀಲಿಂಗ್ ಆಗಿರೋದಕ್ಕೆ ಇವ್ರು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಬರೀಬೇಕಲ್ವಾ ಇಲ್ಲಿ? ಇದು ಯಾವ್ದು ನೋಡು? 5493 connected with WP 905722 or disposed of along with A1 of 5493 ಜೊತೆ ಇದೆ ಇದು. ಹಂಗಂದ್ರೆ ಇದನ್ನು ಅದ್ರ ಜೊತೆನೆ ಇದು
5493 ಜೊತೆ 9057 ಡೀಲಿಂಗ್ ಆಗ್ಬೇಕಂದ್ರೆ ಅದ್ರ ಜೊತೆಗೆ
ಅಲ್ಲ ಅಲ್ಲೇ ಏನ್ ಹಾಕಿದ್ದಾರೆ ನೋಡಿ. 5493
ಮೂರು ಸರ್ ಮೇಡಮ್ ಸರ್ 3 ಪೆಟಿಷನ್ ಒಟ್ಟಿಗೆ ಅಂತ ಹೇಳಿ ಸಪರೇಟ್ ಏನಿಗೆ ಅದು ಎಲ್ಲಿ ಇದೆ ಸರ್? ಅದು ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ.
ಡಿಸ್ಪೋಸ್ಡ್ ಅಲ್ಲಿ ನೀವೇನು ಐಏನು ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. ಅಲ್ಲ ಇದ್ರೆ ಕರೆಕ್ಟ್ ಡಿಸ್ಪೋಸಲ್ ಮ್ಯಾಟರ್ ನ ಲಿಸ್ಟ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಆರ್ಡರ್ ಅದ್ರಲ್ಲಿ ನೀವು ಐಏನು ಹಾಕಿಲ್ಲ, ಏನು ಹಾಕಿಲ್ಲ. ಇದೆಲ್ಲ ಏನಪ್ಪ ಇದು?
ಈಗ ಹುಡುಗಿಗೆ ಹಂಗೆ ಹೇಳಿ ಮತ್ತೆ 9057 ಬರ್ಲಿ ನಾಳೆ ನೋಡೋಣ. ಇದನ್ನ ಮಾತ್ರ
ಟೆಂಪ್ಲೇಟ್ ಅಲ್ಲಿ
ಇದನ್ನ ಮಾತ್ರ ಮಾಡ್ಸೋಣ.
ಬರ್ಲಿ ಬಿಡಿ, ನೀವು ಇವಾಗ ಏನೋ ತೆಗಿಸ್ಬೇಡಿ. ಆಮೇಲೆ
ಅದೊಂದನ್ನ ಮಾತ್ರ ತಗೊಂಡು ಚೇಂಬರ್
ಅಲ್ಲ ಮೇಡಮ್ ಅವ್ರಿಗೆ ಹೇಳಿ ಅವ್ರು ಆರ್ಡರ್ ಟೈಪ್ ಮಾಡ್ಬಿಡ್ತಾರೆ. ಇದನ್ನು ಬರ್ಲಿ ನಾಳೆಗೆ ಅಂತ ನಾನು 9057 ಇದ್ರ ಜೊತೆ ಬರ್ಲಿ. ಇದೊಂದನ್ನ ಮಾತ್ರ ಇವಾಗ ಆರ್ಡರ್ ಮಾಡ್ಸೋಣ. 8683 ಮಾತ್ರ ಆರ್ಡರ್ ಆಗುತ್ತೆ. ಅದೆಲ್ಲ ನಾಳೆ ಬರ್ಲಿ. ಇದು ಕೆಪ್ಪಿಲ್ಲ ಮಾಡ್ಬೇಕಲ್ಲ. ಅಲ್ಲ ಇದು ಮಾತ್ರ ತಗೊಂಡಿದ್ದೀನಿ.
ಫೈಲ್ ಮಾತ್ರ ಕಳಿಸ್ತೀನಿ. ಅಲ್ಲ ಈ ಅಮ್ಮನ್ಗೆ ಕೇಸ್ ಇದೆ ಅಂತ ಗೊತ್ತು ತಾನೆ? ಅವ್ರು ಪಾರ್ಟೀಸ್ ಪ್ರೆಸೆಂಟ್ ಇರಕ್ಕೆ ಹೇಳಿದ್ರ ಸರ್? ಮತ್ತೆ ಬೆಳಗಿನ ಅಡ್ವಾನ್ಸ್ ದೇ ಹ್ಯಾವ್ ಟು ಕಮ್ ಟು ದ ಕೋರ್ಟ್ ಅಲ್ವಾ?
ಇಲ್ಲ ಮುಗ್ದೋಗಿರೋದ ಸರ್ ಸುಮ್ಮನೆ ಮತ್ತೆ ಅಂತ ಆಗುತ್ತೆ.
ಇವ್ರು ನೋಡು ಈ ಟೈಪಿಂಗ್ ಫೋನ್ ಅವರು ಎತ್ತದೇ ಇಲ್ಲ ಫೋನ್. ಯಾರಿಗೆ ಹೇಳೋದು? ಡಿಸ್ಕನೆಕ್ಟ್ ಮಾಡಿ ಮಾಡಿ ಇರ್ತಾರೆ. ಹಲೋ ಮೇಡಮ್, ನೀವು ಸ್ವಲ್ಪ PHMಗೆ ಫೋನ್ ಕೊಡಿ. ಅವ್ರಿಗೆ ನಾಳೆಗೆ ಡೇಟ್ ಮ್ಯಾಟ್ರಲ್ಲಿ ಏನೋ ಡೈರೆಕ್ಷನ್ ಕಟ್ ಮಾಡಿ ಮಾಡಿ ಇರ್ತಾರೆ. PHM ಲಿಸ್ಟ್ ಟುಮಾರೋ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲಪ್ಪ, ಅದರಲ್ಲಿ 9057 ಟೆಂಪ್ಲೇಟ್ ಮಾಡ್ಬಿಡು, ಅದು ಅದ್ರ ಜೊತೆ ನಾಳೆ 3 ಬಂತು. ಇದೊಂದನ್ನು ಮಾತ್ರ ಸೆಪರೇಟ್ ಅದೇ ಈಗ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ ಅದರಲ್ಲಿ ರೀಕಾಲ್ಡ್ ಅಷ್ಟೇ ಮಾಡಿ ಅದು ಚೇಂಬರ್ ಅಲ್ಲಿ ಇನ್ನೇನು ಕಂಟಿನ್ಯೂಷನ್ ಆಗುತ್ತೋ ಅದನ್ನ ಕ್ಯಾಚ್ ಅಪ್ ಮಾಡ್ಕೊತಾರೆ ಅವರು. ಇದು ಮೂರನ್ನು ತೋರಿಸ್ಕೊಳಪ್ಪ ಟೆಂಪ್ಲೇಟ್ ಅಲ್ಲಿ ಎಕ್ಸೆಪ್ಟ್ ದಿಸ್ ಏನ್ ಆರ್ಡರ್ ಮಾಡ್ತಿದ್ಯಾ ಇದನ್ನ ಮಾಡ್ಬಿಟ್ಟು ಇನ್ನು ಉಳಿದಿದ್ದು ಲಿಸ್ಟ್ ಸುಮಾರು ಅಂತ 86, 83 is delinked ಅಂತ ಮಾಡ್ಬಿಟ್ಟು ಲಿಸ್ಟ್ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅದರಲ್ಲಿ ಆ ಮೂರನ್ನು ತೋರಿಸ್ಬಿಟ್ಟು ಮೇಲ್ಗಡೆ ಟಾಪ್ ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಅದು ಇದು 86, 83 ಡಿಲಿಂಕ್ ಮಾಡ್ಬೇಕಲ್ಲ.
ಅದ್ ಮಾಡಕ್ಕೆ ಅಲ್ಲಿ ನಾನು ಸ್ಕೂಲಿಗೆ ಇದು ಮಾಡಿದ್ದೀನಿ.
ಅಲ್ಲಲ್ಲ ಇಲ್ಲಿ ಬರ್ದ್ಬಿಡು WP
ಮೇನ್ ಫೈಲ್ ಮಾತ್ರ ಬರೀತೀನಿ.
ಅದೇನೆ
83 ಮಾತ್ರ ಡಿಲಿಂಕ್.
ಅದೇನೆ ಅದೊಂದು ಫೈಲೇ ಡಿಲಿಂಕ್ ಆಗಿದೆ, ಇದ್ದಿದ್ದೆಲ್ಲ
ಇದ್ರಲ್ಲೇ ಇದೆ. ನಾಳೆ ಬರುತ್ತೆ.
549 ಇದನ್ನೆಲ್ಲ ಬರೆಯೋದು. ಮೈನ್ ಫೈಲ್ ಯಾವ್ದಿದೆ ನೋಡು 34901 ತಾನೇ ಮೈನ್. ಅದೇನೆ 34901 ಅನ್ಸುತ್ತೆ ನೋಡೋದು. ಆ 949757 ಇದ್ರ ಜೊತೆನೆ ಈಗ ಬರೀ ರಿಪೀಟ್ ಕೊಡ್ತೀರಾ ಕೊಡ್ತೀರಾ?
ಇಲ್ಲ ಮೇಡಮ್ ರಿಪೀಟ್ ಎಲ್ಲ ಕೊಡಲ್ಲ. ಯಾಕೆ ಹೇಳಿ? ಕೊಟ್ರೆ
ಆಯ್ತು. ಇದನ್ನ
ಹ್ಞೂ ಮೇಡಮ್
3 ಫೈಲು ನಾಳೆಗೆ ಆಯ್ತಾ? ಅದ್ 3 ಫೈಲು ಕಟ್ಟಿರ್ತೀವಿ.
WP 83 is restored ಅಂತ ಬರೀಲ್ಲ. and delinked and restore ಮಾಡಿದ್ರಲ್ಲ.
restored delinked and restored ಅಂತ ಮಾಡು.
ನೋಡಿ ಇವಾಗ ಅದು ಆ ಮೂರನ್ನು ಕಳಿಸ್ಬೇಕು. ಇದೊಂದು ಸಪರೇಟ್
ಆ ಫೈಲ್ ಇಸ್ಕೊಂಡ್ಬರ್ಬೇಕು. ಸದಾ ನೋಡಮ್ಮ ಆ ಹುಡುಗಿ ಮಾಡ್ತಾ ಇರ್ತಾಳೆ ಅನ್ಸುತ್ತೆ. ಇನ್ನೊಂದು 5 ನಿಮಿಷ ಬಿಟ್ಟು ಹೋಗು. ಯಾಕೆ ಗೊತ್ತಾ? ಇನ್ನೊಂದು 5 ನಿಮಿಷ ಬಿಟ್ಟು ಟೈಪ್ ಮಾಡಿ.
ದಾರ ಕೊಡಿ.
ದಾರ ಇಲ್ವಾ? ಇದು ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟು ಇದು ನಾಳೆಗಿದೆ ಡೇಟ್. ಇದು ಆರ್ಡರ್ ಶೀಟ್ ಇದಕ್ಕೆ ಏನು ಬೇಡ ಅನ್ಸುತ್ತೆ. ಈಗ ತಂದು ಆರ್ಡರ್ ಶೀಟ್ ಸೇರ್ಸ್ಕೊಳ್ಳೋದಾದ್ರೆ ಇಲ್ಲೇ ಇಟ್ಬಿಟ್ಟು ಆರ್ಡರ್ ಶೀಟ್ ಸೇರ್ಸ್ಕೊ. ಹಂಗ್ ಮಾಡು. ಈಗ ಅವಳನ್ನ ಕೇಳು ಫೈಲೇ ಬೇಕಂತ ಬೇಕು ಅಂತ ತಾಳ್ಕೊಡು. ಇದು ನಾಳೆಗಿದೆ. ಇದಿಷ್ಟು ಆರ್ಡರ್ ಶೀಟ್ ಒಂದೊಂದು ಟೈಪ್ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂದ್ರೆ ಈಸ್ಕೊಂಡ್ಬಿಡು. ಅದ್ರದ್ದು ಆರ್ಡರ್ ಶೀಟು ಇದ್ರ ಡ್ರಾಫ್ಟ್ 2 ಇಸ್ಕೊಂಬ. ಇದು 3 ಕನೆಕ್ಟ್ ಮಾಡಿ ಒಂದು ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ತಾಳೆ. ಮೇನ್ ಮ್ಯಾಟರು ಇದು ಎಲ್ಲ 86, 83 ಸೆಪರೇಟ್ ಕೊಡ್ತಾಳೆ ಆರ್ಡ್ರು.
ಫೈಲು ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ. ಫೈಲು ಇಸ್ಕೊಂಡ್ಬಂದು ಫೈಲ್ ಅವಳ ಕಡೆ ಐತೆ. 86, 83 ಚೇಂಬರ್ಗೆ ಹೋಗ್ಬೇಕದು.